woman at the defense table didn't look up when the bailiff called the room to order. Fired for what? Simone Vega was 26 years old, and she had $3.42 in her checking account. A studio apartment in East Baltimore with a radiator that knocked all night, and a folder, one single manila folder, that she'd been carrying under her arm since 6 o'clock that morning. The folder was thin. That was the first thing opposing counsel noticed. Kenneth Bryce, 51 years old, senior partner at Bryce & Alderman, 32 years in corporate litigation, noticed it the way a man notices a child bring a pocket knife to a gunfight. He allowed himself a small exhale that wasn't quite a laugh. He set his own binders on the table, 4 of them color-tabbed, each one thick as a dictionary, and uncapped his pen. The courtroom was on the 4th floor of the Whitmore building, a private arbitration space that cost $600 an hour to rent. The company was paying for it. The company paid for most things in this room. The arbitrator, retired judge named Sylvia Cabot, sat behind a long oak table and reviewed her notes without looking at either party. Simone Vega looked at the ceiling. She had not slept. She had been awake since Tuesday morning, and it was now Thursday, and the hours between had been spent at the kitchen table of her mother's house in Highlandtown. Her mother, Yvette, who worked the overnight shift at a hospital laundry facility and came home each morning with her wrists aching. Spread across that table were 47 pages of documentation that Simone had requested, filed for, been denied, re-requested, and finally received on a CD-ROM from the Equal Employment Opportunity Commission field office on Lombard Street. She had read every page 3 times. The folder under her arm held 9 of those pages, the 9 she needed. Bryce & Alderman represented Crestfield Financial Group, which was the company that had employed Simone Vega for 2 years and 4 months as a junior data analyst, and which had terminated her employment 11 weeks ago on a Thursday afternoon at 4:47 p.m., which she knew because she had looked at the clock on her computer screen in the exact moment her manager, a man named Todd, appeared at her cubicle and asked her to come with him to HR. The stated reason, performance concerns. The real reason was something else, and Simone knew it, and Bryce knew it, and the woman who ran HR knew it, and approximately 8 other people at Crestfield Financial Group knew it, and none of them thought that Simone Vega, 26, no law degree, no union, no connections, representing herself in a private arbitration proceeding because she could not afford the retainer for an employment attorney, was going to be able to prove it. That was the thing about folders that looked thin. Sometimes the thickness of the binder was the only bluff in the room. 3 months before she was fired, Simone had found something. She hadn't been looking for it. She had been doing what she was paid to do, running variance reports on Crestfield's regional loan performance data. When a number didn't match, not by much, $11,000 across a 3-quarter period, buried in a line item labeled Administrative Reconciliation, which was not a category that appeared anywhere in the company's public-facing financial disclosures. Simone had a degree in applied mathematics from Coppin State University. She had graduated 3rd in her class. She had received no job offers at graduation, attended 7 interviews over 4 months, been told twice that she was a strong candidate but not quite the right fit, and had finally been hired at Crestfield through a diversity recruitment initiative that the company publicized heavily in its annual report. She was good at her job. Her supervisor, Todd, had told her so in her 12-month review. He had written the word exceptional on her evaluation form. She flagged the discrepancy in an internal email to her department head, a woman named Patricia, and included a spreadsheet attachment showing the variance across 5 reporting periods. Patricia had read the email. Simone knew she had read it because the red receipt came back 11 minutes after she sent it. Patricia had not responded. 3 days later, Simone sent a follow-up. No response. 2 weeks after that, her annual performance review, which had previously been scheduled for the end of Q3, was quietly moved up. Todd sat across from her in a glass-walled conference room and used phrases like communication challenges and scope overreach and tendency to work outside designated parameters. The evaluation form this time did not contain the word exceptional. Simone had sat very still during that meeting. She had a habit of going quiet when she was paying the most attention, which people consistently mistook for passivity. She was not passive. She went home that evening and requested her personnel file under Maryland state law. She requested the full audit logs for the dataset she had flagged. She submitted a formal inquiry to Crestfield's internal compliance hotline, a number listed on a laminated card in the break room, and received an automated confirmation that her inquiry had been received and would be reviewed within 30 business days. 31 business days later, she was called into HR and handed a termination letter. The arbitration had been Crestfield's idea, or rather, it had been buried in paragraph 19 of the employment agreement Simone had signed on her first day of work when she was 23 years old and had never read an employment arbitration clause in her life. And the HR coordinator had fanned the pages in front of her and pointed to the signature line and smiled. By signing that agreement, Simone had waived her right to a jury trial in any employment dispute. She had agreed that all claims would be resolved by a mutually agreed-upon arbitrator. She had agreed that the proceedings would be private and confidential. She had agreed to a lot of things on that day in that office, with a new hire packet in her lap and the smell of fresh carpet in the air. She had not agreed to stay quiet. Bryce had filed a motion to limit the scope of the arbitration to the termination decision itself, whether Crestfield had cause, whether proper procedure was followed, whether the documented performance concerns were legitimate. He had filed it professionally, thoroughly, with 43 attached exhibits. He had also, in the cover letter, referred to Simone's complaint as an employment grievance arising from a misunderstanding of internal data processes, which was a very precise way of saying that she had confused herself with the numbers and was now embarrassing everyone. Simone had read that cover letter 4 times. She had submitted her response 3 pages, no exhibits, and asked that the scope include the financial discrepancy she had identified and the subsequent chain of events. Arbitrator Cavett had reviewed both submissions and, at the preliminary conference, had indicated that she would hear both matters. Bryce had not liked that. He had said so, politely, with a great deal of procedural language. Cavett had looked at him over her reading glasses and moved on. The hearing began at 9 o'clock. Bryce opened for 45 minutes. He was good at it, organized, authoritative, the kind of voice that filled a room without seeming to try. He walked through Simone's personnel file with the precision of a surgeon. He had her quarterly output numbers. He had Todd's documentation of the performance concerns, which stretched back, he noted, further than Simone had perhaps realized. He had a signed statement from Patricia explaining that Simone's internal email had been reviewed and found to reflect a misapplication of the variance methodology used by the department. He said the word methodology with the particular confidence of a man who knows the other person in the room is less credentialed than he is. Then he sat down. Cabot looked at Simone. "Ms. Vega, you may respond." Simone stood up. She set the manila folder on the table in front of her and did not open it. "The company says I was fired for performance," she said. "They have documentation that goes back 8 months. I want to ask about the timing of when that documentation was created." Bryce leapt up from his notes. "The audit log for my personnel file," Simone continued, "which I received under my right to access under Maryland Labor and Employment Code Section 3428, shows that 6 of the 8 performance memos Mr. Bryce just referenced were added to my file between October 14th and October 19th of last year." She opened the folder. She placed the first page on the table, face toward Cabot. "I was terminated on October 22nd. The room was quiet. The email I sent to my department head flagging the financial discrepancy was sent on September 28th. The read receipt shows it was opened at 2:17 p.m. that day." She placed the second page on the table. 6 performance memos created in the 6 days before my termination, 3 weeks after I reported a discrepancy through internal channels. She paused. "I want to ask Mr. Bryce's witnesses about that timeline." Bryce set down his pen. He picked it up again. The first witness was Todd. Todd was 44, broad-shouldered, the kind of man who coached his son's soccer team on Saturdays and believed, genuinely, that he was a fair person. He sat in the chair across from the long oak table and folded his hands and answered Bryce's questions with the practiced ease of someone who had been prepared. When Simone's turn came, she stood up with a single page. "You wrote the word exceptional on my 12-month review," she said, "in the comments section, October of the year before last." Todd glanced at Bryce. "That was based on the information available at that time." "The 12-month review was completed September 3rd, Simone said. The performance memos begin October 14th of the following year. Performance issues can develop over time. They can, Simone agreed. Can you tell me which specific output metric declined between September of that year and October of this one? Todd shifted. It's more qualitative then. You referenced output metrics in your deposition statement, Simone said. She held up the page. Page 3, paragraph 2. You said, and I'm reading directly, Ms. Vega's output quality showed measurable decline in the relevant period. I'm asking which metric showed that decline. Todd looked at his hands. I'd have to review the specific data. I have the data, Simone said. My quarterly output numbers are in Mr. Bryce's exhibit packet, pages 11 through 14. Would you like me to walk through them? Bryce was on his feet. I'd object to. This is arbitration, Mr. Bryce, Cabot said without looking up. You can note your concern. Ms. Vega, proceed. Simone set page 11 in front of Todd. Her numbers were good. They had always been good. The quarterly figures showed consistent performance across all 8 measurable categories, with an upward trend in 3 of them. Todd looked at the page the way a person looks at something they recognize but were hoping they wouldn't have to see. These are your department's metrics, Simone said, the ones submitted to senior leadership. Is there a different data set that shows the decline you referenced? There wasn't, and they both knew there wasn't, and the room knew they both knew. Patricia was the second witness. She was 51, sharp-eyed, the kind of woman who had navigated corporate environments for 25 years by being very precise about what she did and did not put in writing. She had a law degree she had never used in practice. She answered questions in complete, careful sentences. Bryce walked her through the variance email, Simone's flag, Patricia's assessment, the conclusion that the discrepancy reflected a methodology misunderstanding. Can you explain the methodology that was being misapplied? Simone asked. The variance calculation used by our department accounts for reconciliation offsets in a specific way, Patricia said. It's documented in our internal process guide. I'd like to see that process guide, Simone said. Patricia glanced at Bryce. I believe it was included in discovery. It wasn't, Simone said. I reviewed every document in Mr. Bryce's production. The process guide isn't there. I submitted a request for it in my initial discovery list. She turned to Cabot. Item 7 on my requested documents. The response was that it was proprietary and not subject to disclosure. Cabot made a note. I have a different question, Simone said. She opened the folder to the 7th page. The internal compliance hotline. The one listed on the laminated card in the break room. When an inquiry is submitted, where does it go? Patricia waited. It routes to the compliance officer, she said, who reviews it and determines next steps. Who was the compliance officer at Crestfield Financial? At the time in question that was, Patricia paused. Have a second, maybe less, but Simone had been watching for it. At the time in question, Patricia finished, that was Richard Alderman. The room did not make a sound. Simone set page 7 on the table. Richard Alderman was the founding partner of Bryce & Alderman, Kenneth Bryce's firm. The firm that was representing Crestfield Financial Group in this proceeding, the compliance hotline that Simone had used to report the financial discrepancy, the hotline listed on the laminated card in the break room, routed, at the time of her report, to a man who was a named partner at the company now arguing she had been fired for performance reasons. The inquiry I submitted on October 1st, Simone said, 3 days after I sent my email to you, the one I received an automated confirmation for. Can you tell me what happened to that inquiry? Patricia's hands were very still on the table. I'm not aware of the specific handling of that inquiry, she said. Mr. Alderman's firm was retained by Crestfield Financial on what date? Simone asked. Bryce stood up. Ms. Vega, this is October 8th, Simone said before he could finish. She placed the final page on the table. It was a public filing, a notice of representation filed with the Maryland Commission on Civil Rights in a separate matter, listing Bryce & Alderman as counsel for Crestfield Financial effective October 8th of that year, 7 days after her compliance inquiry was received, 14 days before the performance memos appeared in her file. Cabot called a recess at 12:40 p.m. Simone sat in a plastic chair in the hallway outside the arbitration room and ate a granola bar from her bag. She had packed 2 of them that morning because she hadn't known how long the day would go, and she'd been too nervous at 6 a.m. to eat breakfast. Her mother had been awake when she left, still in her work clothes, sitting at the kitchen table with a cup of coffee, and had watched her pack the folder into her bag. "You sure about this?" Yvette had asked. Simone had zipped the bag. "I know what I found." Yvette had looked at her for a moment. She had the kind of face that had spent a long time learning not to show what it was thinking. Then she'd reached across the table and tucked a folded 20 into the front pocket of Simone's bag. "In case you need lunch," she'd said. The granola bar cost $1.49. Simone ate it in 11 minutes, staring at the beige wall across from her, listening to the low murmur of Bryce and his associate conferring behind the closed door of a side room down the hall. She was not afraid. She had been afraid for weeks, in the way that lives in the chest and makes it hard to take a full breath. But sitting in that plastic chair with the empty granola bar wrapper in her hand and 8 pages of documentation filed with the arbitrator, she felt something settle in her that had been unsettled for a long time. She had read every page 3 times. She knew what she had found. That was the only part she was certain of, not the outcome, not what Cabot would decide, not whether any of it would matter in any of the ways she needed it to, only that the numbers had told her the truth. And she had been paying attention, and she had written it down. The afternoon session ran until 4:15. Bryce called 2 more witnesses, a senior analyst who testified about standard data practices, and the head of HR, a woman named Colleen, who walked through the procedural steps of the termination process with the clinical efficiency of someone who had done it many times. Both of them answered Simone's questions in the same careful, non-specific language that Patricia had used. They had prepared for a woman who would ask emotional questions, personal questions, questions about fairness and intent. Simone did not ask emotional questions. She asked about dates. She asked about document creation timestamps. She asked about who had access to what system and when. She asked things that required answers that could be verified because she had verified them, and the only question left was whether the other answers would match. Mostly they didn't. Not in the way that meant anyone lied outright. In the way that meant 6 different people had told slightly different versions of the same story, and the versions didn't fit together when you laid them side by side, and Simone had laid them side by side, and Simone had laid them side by side. At 4:15, Cabot collected her notes, thanked both parties, and indicated that she would issue a written decision within 21 days. She did not say anything else. She did not tell Simone she had done a good job, or that the presentation had been compelling, or that anything had been established. She was a retired judge, and retired judges do not narrate conclusions before they're ready to reach them. Bryce shook his associate's hand and began packing his binders. He did not look at Simone. Simone picked up her folder. The 9 pages were still inside it, slightly reordered from where she'd placed them on the table and then taken them back. She took the elevator down to the lobby, pushed through the revolving door into the October air, and stood on the sidewalk for a moment. The street was loud. A bus went by. Someone was selling chestnuts from a cart at the corner, and the smell of them came to her on the wind, warm, slightly smoky, like something from a different season. She called her mother. The phone rang twice. "How'd it go?" Yvette asked. Simone looked down the block. "I did what I could do." "That's all you had to do." The written decision came on a Tuesday. It came as a PDF attached to an email from Cabot's office, and Simone opened it at the kitchen table at 7:23 in the morning, on her phone, sitting in the same chair she had sat in for 3 months of preparation. The document was 14 pages. She read all 14 pages before she let herself feel anything. The arbitrator found on the evidence presented that Crestfield Financial Group had not demonstrated sufficient cause for the termination of Simone Vega's employment. The performance documentation, the decision noted, had been created in a compressed time frame that the company had been unable to adequately explain in relation to the prior performance record. The arbitrator further found that the circumstances surrounding the internal compliance inquiry, specifically the involvement of retained outside counsel in the compliance function at the time the inquiry was received, raised sufficient questions about the integrity of the internal reporting process to warrant referral of the financial discrepancy to the Maryland Office of Financial Regulation. She read that paragraph twice. The financial discrepancy was going to be looked at by the right people now. That was the part that mattered most to her, the part she hadn't said out loud to anyone, not even her mother, that the $11,000 in a mislabeled line item was not, she was almost certain, just $11,000. She didn't know what it was exactly. That wasn't her job anymore. She had found it, she had reported it, and now people whose entire job was that specific thing were going to look at it. The compensation awarded was 14 months of back pay plus attorney's fees calculated at the applicable rate for self-represented parties. She put the phone face down on the table and sat in the quiet kitchen for a while. The radiator in the corner knocked once and went still. The refrigerator hummed. From somewhere outside came the sound of a garbage truck, grinding and reversing, the ordinary machinery of an ordinary morning in an ordinary city that had no idea what had just happened at this table. Yvette was asleep in the back bedroom after her overnight shift. Simone didn't wake her. She went to the window instead and looked out at the street. The row houses, the iron railings, a woman walking a dog in a yellow raincoat, the familiar geometry of the neighborhood she'd grown up in and come back to when she had nowhere else to go. She thought about the 9 pages in the manila folder. She thought about the 60 days of preparation and the sleepless nights and the way Todd had not been able to name a single metric when she asked him to. She thought about Patricia's half-second pause before she said Richard Alderman's name, that tiny hesitation, that small moment when the truth was visible before the careful language closed back over it. She thought about the laminated card on the break room wall. There was something she had always known, that she had known since the first time a teacher handed back a test and seemed surprised by her score, that she had known in every interview room where someone looked at her resume and then looked at her and took a fraction of a second longer than they should have to reconcile what they expected with what was in front of them. She had known it so long that it had become like gravity, something you didn't think about, something you just accounted for, something you moved through. The thing was, gravity was consistent. You could learn to work with it. You could understand exactly how much force it was going to take to lift something, and you could apply precisely that much force, and the thing would lift. She had done the math. She had applied the force. She stood at the window until she heard Yvette moving in the back room, the particular creak of the bed, the slow footsteps of someone who has been on their feet all night and is now, reluctantly, standing again. Then she went to the kitchen and put the kettle on and waited. Some documents don't announce themselves. They sit in a line item in a variance report, in a column of numbers that almost match but don't quite, and they wait for someone who is paying close enough attention to notice. Most people walk past them. Most people have been told in 100 different ways that the numbers in the important columns belong to someone else, that the questions worth asking have already been asked by people more qualified than them, that the right thing to do is to sign the form and go back to their desk. Simone Vega had signed the form. She had gone back to her desk. And then she had read every number on every page 3 times, and she had written it all down, and she had carried it in a thin folder under her arm to a room where no one expected her to win. The kettle began to whistle. I keep thinking about that folder. 9 pages. That's all it was. Not a law degree, not a connected family, not a team of associates billing by the hour. 9 pages inside a manila folder that Simone carried under her arm on a Thursday morning while her mother slept after an overnight shift. And the folder was so thin that a man with 4 color-tapped binders looked at it and almost smiled. That smile's the part I can't stop thinking about. Because the smile was based on something real, on a calculation that had been run correctly 1,000 times before. She was young. She had no legal training. She was representing herself in a room that cost $600 an hour against a firm with 32 years of practice and a client who had already decided how this ended. The math, by every conventional measure, didn't work in her favor. But Simone had done a different kind of math. She had read every number on every page 3 times. She had tracked timestamps and document creation logs and the 11-day window between a compliance inquiry and a law firm's retention date. She hadn't gone looking for a fight. She'd gone looking for an $11,000 discrepancy in a variance report at 4 in the morning, and when she found it, she did the only thing that a person with real integrity can do. She wrote it down and told someone. That's the part that gets missed in stories like this. People focus on the hearing room, on the questions that dismantled Todd's testimony, on the moment Patricia paused half a second before saying a name she hadn't wanted to say. Those moments matter, but they were only possible because of everything that came before them. The 60 days of preparation, the sleepless nights, the requests that were ignored and resubmitted, the formal complaint filed to a hotline that turned out to route directly to the opposing firm's founding partner. None of that was dramatic. None of it felt like winning. It just felt like showing up again in an empty kitchen with documents spread across a table. That's what perseverance actually looks like. Not a montage, a kitchen table at 3 a.m. and a woman who doesn't stop. And here's what I've come to believe from watching people like Simone navigate systems that were not built with them in mind. The intelligence that matters most is not the kind that impresses people in the moment. It's the kind that asks the next question when everyone else has accepted the answer. It's the kind that notices the number that doesn't match, that reads the clause in paragraph 19, that tracks the date a firm was retained against the date a compliance inquiry disappeared. That kind of intelligence is cultivated. It's built through discipline and refusal to accept that the important questions have already been asked by someone more qualified. And underneath all of it, there has to be something that I can only describe as character. Simone could have left the discrepancy alone. She could have flagged it once, received no response, and moved on. Plenty of people would have. The cost of pursuing it was her job, her income, her savings, and 11 weeks of uncertainty that would have broken most people who had $3.42 in their checking account. She didn't leave it alone, not because she was certain she would win, but because she knew what she had found, and she couldn't unknow it. The kettle whistled at the end of that story, and her mother was waking up, and the ordinary morning was assembling itself outside the window. That image stays with me. Not the arbitration room, not the 14-page decision, but that moment at the window. The woman who had just changed the course of her life standing quietly in her mother's kitchen, waiting to make tea. The most important things usually look like that, quiet, ordinary, entirely unremarkable to anyone who doesn't know what it took to get there.